Thanks to those who have dialed into the teleconference for standing by. Welcome to the open meeting of the Public Company Accounting Oversight Board. During the call, you will be in listen-only mode. As a reminder, this meeting is being recorded, and a recording is expected to be made available on the PCAOB website. I would now like to turn to Acting Chairperson Disparte to formally convene the meeting.
Good morning, everyone. This is an open meeting of the Public Company Accounting Oversight Board on September 22nd, 2021. We welcome those who have joined us today by dialing into the teleconference or by listening to the webcast of this meeting. Today, the board will consider a staff recommendation that we adopt a new rule to govern our responsibilities under the Holding Foreign Companies Accountable Act. That statute requires the board to determine whether it is unable to inspect or investigate completely registered public accounting firms located in a foreign jurisdiction because of a position taken by one or more authorities in that jurisdiction. Before we proceed with the agenda, I will note for the record that board members Gashorn Girata and Zeitzman are participating in this meeting and that we are able to hear one another. To present the staff's recommendation on the adoption of the new rule, I will turn to our General Counsel, Ken Lynch.
Thank you. Good morning, Acting Chairperson Disparte and board members Gashorn Girata and Zeitzman. As you know, the Holding Foreign Companies Accountable Act, or Hfcaa, became law in December 2020. The Hfcaa calls for the board to determine whether the board is unable to inspect or investigate completely registered public accounting firms in a foreign jurisdiction because of a position taken by authorities in that jurisdiction. As discussed in the memorandum before you, the Office of the General Counsel recommends that the board adopt new PCAOB Rule 6100 board determinations under the Holding Foreign Companies Accountable Act. The rule would provide a framework for the board to use when making determinations under the Hfcaa. Before the Office of the General Counsel presents its recommendation, I would like to invite Liza McAndrew Newberry, the Director of the Office of International Affairs, to offer some introductory remarks.
Thank you, Ken. Good morning, Acting Chairperson Disparte and board members Gashorn Girata and Zeitzman. The Office of International Affairs is pleased to present to the board, with our colleagues in the Office of General Counsel, a proposed final rule that provides a framework to guide the board in carrying out its responsibilities under the Holding Foreign Companies Accountable Act. The PCAOB's statutory mandate to oversee registered audit firms reflects the global nature of the issuers that list in the U.S. capital markets. Irrespective of domicile, the Sarbanes-Oxley Act provides for a level playing field with respect to oversight of firms that audit the financial statements of U.S. issuers. Specifically, the Act directs that any foreign public accounting firm that prepares an audit report with respect to any issuer shall be subject to the Act and the rules of the board in the same manner and to the same extent as a firm located in the United States. Audit firms that choose to register with the PCAOB and choose to serve as the auditors of U.S. issuers do so with the understanding that PCAOB oversight accompanies those choices. The nature of that oversight is mandated by Congress and includes board inspections and investigations. The board must periodically inspect firms that issue audit reports for U.S. issuers. During those inspections, board staff must obtain documents and information so that it can review audit engagements and quality control systems and perform other procedures. The board also is authorized to conduct investigations of potential statutory, rule, and professional standards violations by firms and their associated persons. To facilitate those investigations, the board can require testimony and the production of documents. Together, inspections and investigations are crucial aspects of board oversight. Congress recently reinforced the requirement under the Sarbanes-Oxley Act for a level playing field. The Holding Foreign Companies Accountable Act requires the Securities and Exchange Commission to take certain actions with respect to issuers that retain a registered public accounting firm located outside of the United States that the board determines it is unable to inspect or investigate completely because of a position taken by an authority in the foreign jurisdiction. In a moment, my colleagues in the Office of the General Counsel will provide details of a final rule addressing the board's responsibility under the Act. Before turning to them, I would like to express my gratitude to my colleague in the Office of International Affairs, Beth Hilliard-Collet, and ask her to address the board's long-standing practice of recognizing the unique situations that can arise with respect to oversight of registered firms located outside of the United States and the cooperative manner in which the board has consistently sought to address conflicts. Beth?
Good morning. Thank you, Liza, and thank you to the board members and our colleagues in the Office of General Counsel, as well as the entire Office of International Affairs. The board has long observed that certain aspects of its inspection and investigation mandates may raise special considerations for non-U.S. firms, including potential conflicts with non-U.S. law and other obstacles. To address these, the PCAOB has, since its inception, invested in developing a cooperative framework with fellow regulators that is built on a foundation of trust, candor, and a mutual interest in protecting investors. In some jurisdictions, the PCAOB conducts oversight without the involvement of local authorities. In others, the board has entered into cooperative arrangements with international counterparts to facilitate cross-border oversight. The PCAOB benefits greatly from cross-border cooperation and has built constructive relationships that facilitate meaningful oversight. The board's cooperative approach to oversight of PCAOB registered firms located outside the United States has not entailed any abandonment of the board's inspection or investigation mandate or any relinquishment of the board's statutory authority. Instead, the board has worked successfully with its international regulatory counterparts based on norms of international comity to maintain a consistent approach to oversight of all registered firms, whether located in the United States or abroad. International comity simply means a mutual respect for each regulator's mandate, finding protocols and practices whereby each jurisdiction's mandate is facilitated and neither mandate is diluted or compromised. The PCAOB has always been transparent about the essential requirements of its statutory mandate, applicable fully to all auditors participating in the U.S. capital markets. No matter where a firm is located, we must conduct inspections and investigations consistent with the Sarbanes-Oxley mandate. We must be able to select the U.S. audit work for review or investigation, and we must have access to the audit-related information, including testimony that we deem relevant. In some cases, negotiations to address legal obstacles and sovereignty concerns have been protracted, impeding the board's ability to conduct inspections and investigations of certain non-U.S. firms. In response, the board began publishing and still maintains on its website relevant information for investors and the public about this gap in regulatory oversight. Building on the board's commitment to transparency and a level playing field, the rule the board will consider today will promote transparency into the board's processes and ensure consistency over time in how the board exercises its judgment in applying the requirements of the Holding Foreign Companies Accountable Act. I will now turn to my colleagues in the Office of General Counsel to provide further details about the rule.
Thank you, Liza and Beth. The Office of the General Counsel is grateful for the opportunity to collaborate with the Office of International Affairs and other PCAOB divisions and offices on this rulemaking project. I also would like to thank the attorneys in my office who worked on this project, including John Cook, Drew Dropkin, and Damon Andrews. Senior Associate General Counsel Drew Dropkin will now present the recommendation.
Thank you, Ken. Good morning, Acting Chairperson Desparte and board members Goshorn, Girata, and Zietzman. Today, the Office of the General Counsel presents for the board's consideration a recommendation to adopt new PCAOB Rule 6100 entitled Board Determinations under the Holding Foreign Companies Accountable Act. As already noted, the Hfcaa calls for the board to determine whether it is unable to inspect or investigate completely registered public accounting firms in a foreign jurisdiction because of a position taken by authorities in that jurisdiction. In May of 2021, the board issued for public comment a proposed rule that would provide a framework for the board's determinations under the Hfcaa. The board received 8 comment letters, which have been reviewed and considered by the board and by PCAOB staff. The Office of the General Counsel now recommends that the rule be adopted as proposed, with some modifications after consideration of those comments. I'll briefly summarize the central features of the rule, and after doing so, I'll identify 6 significant changes that have been made to the rule since it was first proposed in May of this year. To start, the rule provides for 2 types of determinations that the board may make. First, the board may make determinations as to a particular foreign jurisdiction. If a foreign authority articulates or maintains a position that applies generally to PCAOB inspections or investigations in its jurisdiction, that position could provide the basis for a jurisdiction-wide determination by the board. Under the rule, a jurisdiction-wide determination would apply to all registered firms headquartered in the jurisdiction. Second, and complementing the board's ability to make jurisdiction-wide determinations, the board also may make determinations as to a particular registered firm that has an office in a jurisdiction whose authorities have taken a position that makes the board unable to inspect or investigate that firm completely. With respect to both types of determinations, the rule ties the board's ability to inspect or investigate completely to the board's mandate with respect to inspections and investigations set forth in the Sarbanes-Oxley Act of 2002. Specifically, when making determinations under the rule, the board will assess whether the position taken by the foreign authority impairs the board's ability to execute its statutory mandate with respect to inspections or investigations. That assessment is driven, under the rule, by 3 factors. The first is the board's ability to select engagements and audit areas to be reviewed during an inspection and to select potential violations to be investigated during an investigation. The second is the board's timely access to and its ability to retain and use any document or information in the possession, custody, or control of registered firms or their associated persons that the board considers relevant to an inspection or investigation. The third is the board's ability to conduct inspections and investigations in a manner consistent with its statutory mandate and the rules of the board. This third factor captures all of the other aspects of the board's statutory mandate that are not already subsumed in the first and second factors. If the board's ability to execute its mandate is impaired in any one of these 3 respects, a board determination would be warranted. In addition to identifying the factors that the board would evaluate, the rule also describes the documents and information that the board could consider when making a determination. In this regard, the rule provides that the board may consider any documents or information it deems relevant. Then, for the avoidance of any doubt, the rule identifies certain categories of documents and information that the board may consider. The rule also provides that a board determination need not depend on the board's commencement of, but its inability to complete an inspection or investigation. As for the timing of board determinations, the board would make any determinations that are appropriate promptly after the rule becomes effective. Thereafter, the board would consider, at least annually, whether changes in facts and circumstances support any additional determinations, and would make such determinations when appropriate to allow the Securities and Exchange Commission on a timely basis to identify covered issuers as contemplated by the Hfcaa. Under the rule, when the board makes a determination, the board's determination would be issued in the form of a report to the commission. The board's report would describe the board's assessment and the basis for the board's determination. Firms that are subject to the determination would be identified in an appendix to the board's report. The appendix would identify each firm by the name under which it is registered with the board and by its identification number with the board. Promptly after the board's report is issued, a copy of the report would be made publicly available on the board's website, subject to confidentiality limitations as to certain portions of the report. Additionally, a copy of the report, subject to those same confidentiality limitations, would be sent by electronic mail to each firm that is subject to the board's determination. The rule provides that firms that are subject to a determination must notify the PCAOB secretary within 5 days of any change to the firm's information that's contained in the appendix to the board's report. This will enable the board to update the appendix when appropriate if such a firm, for example, changes its name or the location of its headquarters or offices. The rule also provides that the board may update the appendix to a board report at any time. Under the rule, a board determination would become effective on the date the board issues its report to the commission, and it would remain in effect until it is reaffirmed, modified, or vacated by the board. The board, at least annually, will reassess each determination that is in effect. And apart from that annual reassessment, the board may reassess a determination on its own initiative or at the commission's request at any time. When reassessing a determination, the board will reevaluate the 3 factors identified in the rule. And based on that reevaluation, the board will reaffirm, modify, or vacate its determination and will issue a new report to that effect. Having summarized the key features of the rule, I'll now turn to the changes that have been made to the rule since it was first proposed in May 2021. In addition to a number of revisions that are intended to enhance the clarity, precision, simplicity, and readability of the rule incorporates 6 significant modifications from the original proposal. First, the second factor that the board considers when assessing whether a determination is appropriate has been revised to refer to timely access to documents, information, and personnel, because timely access is critical to the board's fulfillment of its statutory mandate. Second, the rule now provides that a copy of the board's report to the commission regarding a determination will be sent by electronic mail to each firm that is subject to the determination promptly after the report has been issued. Third, the rule has been revised to provide that the list of firms that are subject to a determination will be contained in an appendix to the board's report rather than in the report itself. Fourth, and relatedly, the rule now provides that firms that are identified in the appendix must notify the PCAOB secretary of any changes to the firm's information in that appendix within 5 days of the change. Fifth, the rule now provides that the board may update the appendix to a board report at any time if the information in the appendix has changed or if a discrepancy has been identified, and the board may do so without reassessing the underlying determination. Sixth, and finally, the rule has been revised to provide that the board, at least annually, will reassess each determination that is in effect, and at the conclusion of that reassessment, will issue a report reaffirming, modifying, or vacating the determination. The Office of the General Counsel believes that adopting this rule would inform investors, registered firms, issuers, audit committees, foreign authorities, and the public at large as to how the board will perform its functions under the Hfcaa. Furthermore, adopting this rule, in our view, would promote consistency in the board's determination process. The Office of the General Counsel therefore recommends that the board adopt new PCAOB Rule 6100 and issue an adopting release in substantially the form attached to the recommendation memorandum before you. The Office of the General Counsel also recommends that the board direct staff to submit Rule 6100 to the Commission on Form 19B4 for approval pursuant to Section 107B of the Sarbanes-Oxley Act of 2002. In closing, I want to recognize the valuable contributions of staff throughout the organization to this rulemaking project. First, I want to thank my colleagues in the Office of the General Counsel, especially Ken Lynch, John Cook, Damon Andrews, Phoebe Brown, Mohammed Sosa, and Jennifer Williams. I also want to thank Liza McAndrew Mowbray and Beth Hilliard-Colley in the Office of International Affairs, with whom we have the pleasure of working very closely on this rulemaking. I also want to thank Nayantara Hensel, Michael Gerbett, Rashawn Inget, and Tian Liang in the Office of Economic and Risk Analysis, David Hardison in the Office of the Chief Auditor, Carol Swaniker, Abina Glasgow, and Polly Jans in the Division of Registration and Inspections, and John Abel and Bill Ryan in the Division of Enforcement and Investigations for all of their efforts. Finally, I want to thank the Commission staff for their support and assistance. With that, we would be glad to answer any questions. Thank you.
Acting Chairperson Desparte.
Thank you, Ken. I was on mute accidentally. Thank you for that. So thank you, Mr. Dropkin. Thank you, Mr. Lynch, Ms. McAndrew Mowbray, and Ms. Colley, as well as all the staff that Drew mentioned in his remarks. At this time, my fellow board members and I will have an opportunity to make a statement or to ask questions of the staff. We will proceed in the order of seniority, and I will begin. I fully support adoption of PCAOB Rule 6100 as set forth before us today. Robust inspections and investigations of registered public accounting firms that audit U.S. public companies are core to the PCAOB's oversight mandate under the Sarbanes-Oxley Act. This is true whether such firms are located inside or outside of the United States. Through the passage of the Hfcaa, Congress reaffirmed the importance of our oversight activities in providing protection for investors in all U.S. public companies, regardless of where the company's audit firms are located or where their audits are performed. Rule 6100 establishes a framework for the determinations we are required to make under the Hfcaa. This framework will help to promote consistency in our determinations and to provide transparency to investors, firms, issuers, foreign authorities, and other market participants as to the factors the board will consider and the processes it will use in making and publicly reporting its determinations. Furthermore, the framework includes a mechanism whereby the board will reassess its determinations every year, which will provide increased clarity and certainty to market participants over time. Transparency of the board's framework is particularly important given the potential consequences that might follow board determinations under the Hfcaa for issuers, investors, and the broader capital markets. In addition to setting forth the key factors the board will assess in making determinations, the rule promotes transparency by requiring the board to describe in a public report its assessment and the basis for its conclusions for any determination it makes. The rule also requires the board to reassess its determinations at least annually, which will help ensure market participants remain timely informed of the status of our ability to inspect or investigate completely audit firms in the covered foreign jurisdictions. In this way, the final rule provides more certainty to market participants than was provided by the two-step reassessment approach set forth in the original proposal. I therefore support the rule before us. It provides the board a clear and consistent approach for making its determinations and for keeping all interested market participants well informed through timely public reporting. In closing, I want to thank all of those at the PCAOB who have contributed to developing today's final rule, including our staff in the Offices of International Affairs, General Counsel, and Economic and Risk Analysis, and with special recognition for Liza McAndrew-Mowberry, Beth Hilliard-Cowley, Ken Lynch, Drew Dropkin, and Damon Andrews. I also want to thank the Commission staff for their support and assistance. I will now turn to board members Gosshorn-Girada and Zietzman for any statements they may wish to make or questions they would like to pose to the staff. Board member Gosshorn-Girada, the floor is yours.
Great. Well, thank you, Dwayne. And first, I want to congratulate and thank the members of the PCAOB staff who drafted the proposed rule, carefully considered the comments we received from the public, and thoughtfully revised the rule so that we can timely respond to Congress's mandate and the Holding Foreign Companies Accountable Act. I also want to thank the SEC staff for their assistance in review. In particular, I want to thank Ken, Liza, Beth, and Drew for presenting today's recommendation. I'd also like to thank Martha Kidd, who's my special counsel, for all of her assistance as well. It is with great pleasure that I support the adoption of this rule. Consistent and accurate financial statements are one of the fundamental features that allow our equity markets to operate efficiently and effectively. As I said in my statement at the time that we proposed this rule, investors who are saving their hard-earned money for important things like college tuition and retirement by investing in the U.S. capital markets need to be able to trust that that information in companies' financial statements is accurate. High-quality audits and the PCAOB's regulation of auditors play critical roles in enabling investors to rely on the information in financial statements. Registered audit firms that audit companies traded in the United States are subject to the PCAOB's rules and standards, and all of those firms should be subject to the same inspection and enforcement oversight, regardless of where they are located. The PCAOB strives to protect all investors who purchase securities in the U.S. capital markets, as we must to fulfill our statutory mandate. Issuers who are availing themselves of the U.S. capital markets should not be listed on our exchanges if their auditors are not subject to our inspections and investigations to the same extent as firms located in the United States. The Holding Foreign Company Accountable Act seeks to address any potential regulatory gap created by positions taken by authorities in foreign jurisdictions and to ensure that auditors of issuers in those jurisdictions are subject to the same oversight. This is imperative for the PCAOB to facilitate its statutory mandate to protect investors. I know that's somewhat repetitive of what I just said, but it's important to reiterate that point. With that being said, I also want to emphasize two additional points. First, it is paramount for us to formalize the PCAOB's determination mechanism and a rule to promote transparency and consistency. It is important to me that, as we implement Congress's will, we strike the right balance. I want to ensure that all firms auditing issuers listed in the United States can be inspected and investigated completely by us. And I want to balance that goal with careful stewardship of our capital markets. I want to ensure that our markets continue to operate efficiently, effectively, and without unintended consequences. The determination mechanism that we have described is designed to provide a transparent process that will allow investors to understand which firms we are unable to inspect and to consider how that might affect the issuers in which they are investing. Second, the ultimate effect on issuers will be the result of a multi-step process, and the PCAOB's rulemaking today and any eventual determinations in the future are only some of the steps that the Hfcaa requires. For example, the SEC has also engaged in rulemaking to implement the Hfcaa. And if the PCAOB determines that there are firms that it cannot inspect and investigate completely, the SEC will need to identify issuers who have retained those firms and designate non-inspection years for those issuers. The SEC will also need to develop and implement a process for prohibiting the trading of those issuers' securities if the PCAOB is ultimately unable to investigate or inspect those issuers' audit firms completely for 3 consecutive inspection years. However, the PCAOB's adoption today of this new rule marks a critically important step in this multi-step process, and I am proud of the work done to get here. While I was pleased with the proposed rule that we released in May, I believe the final rule includes several improvements. Thank you to all the commenters who provided thoughtful and helpful feedback on the proposed rule. We carefully considered your comments and were able to make improvements to the rule as a result. One of the changes of the rule that I'm most pleased with is the decision to require that our determination be reassessed on an annual basis. The combination of the annual reassessment and the ad hoc reassessment performed when facts and circumstances warrant will help to make sure that the most up-to-date information is considered when we provide our determinations to the SEC and provide additional transparency to investors. The annual reassessment also aligns with the Hfcaa's cadence, including the SEC's identification of issuers and designation of non-inspection years. I am pleased and proud to support the adoption of this rule, and I congratulate and commend all of the staff who worked to draft the rule on an expedited basis to fulfill Congress's mandate. Thank you.
Thank you, Board Member Gosshorn-Gerada. Board Member Zietsman, the floor is now yours.
Thank you, Dwayne. And I too am pleased to support the adoption of PCAOB Rule 6100. The Sarbanes-Oxley Act mandates that the board inspect PCAOB registered firms and investigate possible violations of applicable laws and professional standards by those firms and their associated persons. This mandate applies with equal force to registered firms in the United States and those in foreign jurisdictions. It serves to promote audit quality and to enhance the quality of financial reporting by public companies and registered broker-dealers, which serve to protect investors and further the public interest. For many years, the board has worked effectively with its foreign counterparts to fulfill its statutory mandate, and the board continues to benefit greatly from such cross-border cooperation. In a few jurisdictions, however, authorities have taken positions that prevent the board from obtaining the access it needs to conduct its mandated oversight activities. Congress recognized those obstacles when it enacted the Holding Foreign Companies Accountable Act. This act requires the board to determine when it's unable to inspect or investigate completely registered public accounting firms located in a foreign jurisdiction because of a position taken by one or more authorities in that jurisdiction. The act also mandates the actions the Securities and Exchange Commission shall take after the board makes such a determination. The act does not specify the process that the board should follow when making determinations under the act or require the board to adopt a rule governing those determinations. By filling that gap, the adoption of Rule 6100 should provide several important benefits. First, it establishes a conceptual framework for the board's determinations under the Act that's consistent with the core principles that have previously guided the board's approach to international cooperation. In addition, the rule addresses other facets of the board's determinations, including, for example, the content of the determinations, the format in which the board reports accompanying determinations, the format in which board reports will be made available to the public and to registered firms subject to those determinations, and the manner in which determinations under the Act may be reaffirmed, modified, or vacated. By doing so, Rule 6100 should provide and promote transparency and consistency in the processes for determinations made by the board and also reduce regulatory uncertainty. The final rule has benefit from the public comments received on the board's May 2021 rulemaking proposal. After considering those comments, the board's made several changes to the rule as it was originally proposed. These revisions include more clearly identifying the firms to which the board's determinations will apply in a separate appendix to the board's report, and specifying that the board will reassess each determination that is in effect at least annually. These provisions, along with the other elements of the framework in the final rule, should help ensure that the Commission's actions under the Act are based on determinations by the board that reflect the current status of the PCAOB's ability to inspect and investigate firms completely in a foreign jurisdiction. I join my fellow board members in thanking the PCAOB staff in the various offices and divisions who have worked very diligently and thoughtfully on this project. In particular, I would like to thank Liza, Beth, Ken, Drew, and Damon for their thoughtfulness, their hard work, and their dedication, as well as others in the Office of the General Counsel, the Office of International Affairs, the Office of Economic and Risk Analysis, and the Office of the Chief Auditor who've been involved. I'd also like to thank David Hardison in the Office of the Chief Auditor who helped me prepare for today's meeting. Thank you also to the SEC staff for their insights and support.
Thank you, Board Member Zietsman. Unless there is any further discussion from the three of us on the board, I would ask that All in favor of approving the recommendation, please say yes.
Yes.
Yes. Any opposed? Please say no. Hearing no no's, we have unanimous approval, and the recommendation is thereby approved. And so with that, this concludes the PCAOB's open meeting for today. As there is no further business, this meeting is now adjourned. Thank you for your participation, and you may now disconnect from the teleconference.